No, because I stopped it. So it's doing a different one now. So turn that off. And it should be the one that I am doing now should be on. Okay. Mm-hmm. Okay. Okay. All righty. All right, ASAP. Bye-bye. All right, everyone. Welcome to the 187 District Court. Thank you so much for your patience. We were actually speaking with students in high school who were thinking about going in this profession. So that is why we were a little late today. These are the rules of the 187 District Court. You're in a courtroom. Whatever you can do if you were physically in the courtroom, you can't do on this Zoom screen. If you're at your place of employment, then you need to let your supervisor know that you need to take a break because you are in court. There's to be no laying in bed, no doing of laundry, no changing of diapers, no cooking. Again, if you cannot do it in the 187 District Court, if you are here, you cannot do it on this Zoom screen. To all the inmates, you're not to use the chat box. And if you're wearing a mask, please wear it appropriately, which means it should be covering your nose. If you use the chat box, you will be sent back to your cell and we will see you in 30 or 60 days. No one is to use this Zoom as a chance to pick up dates. This is not The Bachelor. This is not The Bachelorette. I know you ask why I tell you this because it's been done before. So that is not allowed. I'm going to open up the breakout rooms. When I open up the breakout rooms, it will invite everyone to go to a breakout room. Do not go to a breakout room unless I specifically call you by name and assign you. To all the defendants or those accused, you will hear your attorney's name. You will not hear your name. If you do not hear your attorney's name, it is because your attorney is Zooming in another courtroom or had to appear in person. So be patient. It's Wednesday. Let's keep it a Wednesday. Let's not turn it into a Monday. If you do not behave appropriately on this Zoom, it will become a Monday because what will end up happening is you will be required, no matter if you're out of county, out of state, out of the country, you will be required to appear in the 187 District Court and your Zoom privileges will be revoked. All right, this is the order of attorneys. Claudine Espinoza, Bo Wood, Doug Campbell, Jonathan Watkins, Ted Wood, Todd McCrae, Ronald Ortman, called Jonathan Watkins twice. Luis Martinez. Is there any attorney that I've missed?
David Woodard.
Oh, I'm so sorry. And David Woodard, you were in here first. You'll be first. I'm sorry. And then Gail Calderala.
And Your Honor, I apologize. I just logged on.
All right. Thank you. Vivek. All right. To all the attorneys, I need to know the name of your client. I need to know whether or not it's criminal trial division or family violence. If you're able to change your, add to your name, the name of your client and whether or not it's criminal trial division or family violence, that would help us greatly and that would move things along quickly. If you're unable to do that, I will do the name change. Attorneys, If you need a continuance, reset, please do not text, call, email Ms. Ferguson. I'm the only one who can give you a reset or give you a continuance. If you have a plea bargain agreement, no matter how small that agreement is, you need to put it in the chat box with the court coordinator. She's listed as Ferguson coordinator. David Woodard, what is your client's name?
Judge, I have an MTR with Laurel Peterson. It's Criminal Trial Division, and I'm conferring with Meredith.
And if we can get Kevin to come into the breakout room with us too.
Yes, just one
Thank
moment.
you.
All right, I'll send you all to breakout room number 2. And attorneys, when I assign you to a breakout room, please be patient. Think of those breakout rooms as doctor's office. When you go there to see a doctor, they're not seeing you right away. They're just checking your weight and blood pressure. Prosecutors have the ability to move throughout the breakout rooms. I guarantee you, if you leave a breakout room to tell me a prosecutor hasn't been there, that prosecutor will see that room is empty, skip over it and go to the next person. Claudine Espinoza.
Good morning, Your Honor. I'm here for Michaela Doty. She is also present. This is a family violence case, and we're here on a motion to modify bond conditions.
All right, I will send you to breakout room number 3.
Thank you, Your Honor.
You're welcome. Bo Wood,
Top of the morning to you, Judge.
top of the morning. Who do you have?
Chris Collins, Criminal Trial Division. Mr. Hunter, Jay Hunter gave me an offer. My client has accepted. He's an inmate. We just need to start the paperwork is all, Judge.
Okay. I'm going to send you to breakout room number 4.
Thank you. Thank you.
Doug Campbell, thank you for changing your screen name. I'll send you to number 5.
Thanks, Judge.
Jonathan Watkins.
Good morning, Your Honor. Can you hear me, Judge?
Yes.
I have Richard Garza, and I was conferring with Hunter Morris. I just need to confer with him briefly.
All right, I'll send you to number 6.
Thank you, Judge.
You're welcome. Ted Wood.
Good morning, Judge. I'm here for Mr. Stribling. I've been conferring with Mr. Martin. It's a family violence case.
I'll send you to number 7.
Thank you, ma'am.
You're welcome. Todd McCray.
Good morning, Your Honor. We have our paperwork in for a plea. Marcus Sanders is the ADA that we have the agreement with, where I've notified Norma and we're waiting on an application and the appeal certification from the clerk, and we'll be ready to go on a plea.
All right, I'm going to send you to breakout room number 8 with your client.
He's actually in my office. Jonathan?
Okay.
Jonathan's sitting right behind me.
Okay, well, as soon as you are done with the paperwork, let me know and I'll send you all to a breakout room so the clerks can swear you in.
Yes, Judge.
All right, Ronald Ortman.
Yes, I'm an appearance attorney for Jesus Lopez, representing Nathaniel Book. It's Criminal Trial Division. Jesus has filed an agreed motion to withdraw on September 7th, 2021. So that's all we're really here for this morning.
All right, Frank Mathis. Frank Mathis. Unmute, please.
Yes, ma'am.
You're inappropriately dressed for court. Put on a shirt.
Yes, ma'am.
Come back when you're dressed appropriately. All right, Mr. Ortman, just a moment, please. Luis Martinez, I'll send you to breakout room number 8.
Thank you, Judge.
You're welcome. Gail Calderola, who do you have?
Carlos Martin,
Criminal Trial Division or Family Violence?
it's the criminal trial division.
I'll send you to number 9.
Excuse me, Judge? No, I don't think my client is there. Again, I was there yesterday on Carlos Martinez all morning.
right.
Yeah, and the bondsman said that they would contact him and let him know. And I called mom this morning because that's the only number I have. My client does not have a phone or an email.
Okay, all right, just give me one moment. Vivek, thanks for changing your name for me. I'll send you to number 9.
Sounds good, Your Honor.
Matthew Allen,
Judge, what do you want me to do?
just give me a moment. I'm gonna come right back to you.
Okay.
Morning, Judge. I have William Soto, and I believe he's got one of each case, so I'm not sure who's taking the lead on it.
All right, I will send you to breakout room number 10.
Thank you.
All right, is there a prosecutor available? Let me see here. Marcus Sanders, are you available? Mr. Carlos Martinez Jr. is still not present.
Yes, Judge.
All right, Deputy Laura, is there a Carlos Martinez in the courtroom?
No, Your Honor, he is not.
All right, the court is going to call 2020 CR 9620, State of Texas versus Carlos Martinez Jr. Could I have the parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
I'm present, Your Honor. My client's not there.
And Deputy Laura, is there a Carlos Martinez in the courtroom?
No, Your Honor, he is not.
All right, this hearing was scheduled at 9 a.m. It is now 9:38 a.m. Deputy Laura, has Carlos Martinez been in the courtroom at all this morning?
No, Your Honor.
This hearing was originally scheduled yesterday, September 14th at 9 a.m. The defendant was a no-show, and the court recalled it for today to see if the defendant would appear. Ms. Calderola, have you had any contact with your client?
No, Your Honor, my client doesn't have a phone or an email, and I've called the mother and she's going to try to find him this morning. I've talked to the bondsman also. This is the man that posted bond and got out of jail like during the transition is why he didn't show up yesterday, because I thought he was in jail. He posted a bond. He supposedly was released, but he didn't get released right after the bond was posted. You know, they have to process it now. So that was why he didn't appear yesterday. Today, he's not there because I have not been able to reach him. I've contacted the bondsman and his mother, and they know that he needs to be there. And mom said she would try to contact him so that he could show up. And I told him to please try to come there before 10:30.
All right, state.
We'd ask that you forfeit his bond and issue a warrant.
All right, that will be granted. And the court will note for the record that this defendant previously did not appear on November 17th, 2020. And at that time, the court issued a bond forfeiture and remanded the defendant without bond. And some other judge, I believe, lifted that. And so he was released and he still has not appeared for court. So the court will grant the state's motion. If you have contact with your client, of course, the court will reconsider.
Okay, thank you, Your Honor.
You're welcome.
May I be excused?
Yes.
Okay.
Judge, can one of the clerks go into room 7 and chat with Ted Wood on his client?
All right, could Robert or Lupe go to number 7, please? And just one moment. All right, and then Todd McCray. If you'll go to breakout room number 1, please, and a clerk will meet you there to swear your client in. All right, John Winter, who do you have?
Judge, I've got Gabriel Guerra. And I was talking with Meredith last time we were in court.
I think if I'm remembering correctly, I think family violence is on this too.
Okay.
Yeah, the new case is family violence.
Case.
Yeah.
Okay, if someone can join us.
All right, I will send you to breakout room number 11. And then if I could see the attorney on Nathaniel Book. Ronald Ortman.
Yes, I'm here. I didn't know if you wanted me or the state's attorney.
Oh, no, I'm requesting you, Mr. Ortman. Let me see if there's a prosecutor available. They may be all in the breakout rooms, Mr. Ortman. And they are. Just give us a moment. Mr. Book, before we end up going on the record, are you aware that your attorney no longer wants to represent you?
Yes, ma'am. I had asked for that.
And is this attorney appointed or retained?
Retained as in.
Did you hire him?
Yes, ma'am.
All right. Are you going to hire another attorney?
No, I do not have the money for that, ma'am.
All right, State, are you aware that Mr. Ortman, who's standing in for Jesus Lopez, they said there was an agreement that there was no objection to the withdrawal by the attorney? It's on Nathaniel Book. Mr. Ortman, who is the attorney?
Jesus Lopez is the attorney on it.
Now, who's the prosecutor that you all conferred with?
Oh, I have no idea. They didn't tell me that from the office. They just asked me to cover this hearing for Jesus this morning.
All right, Marcus, it appears that on Nathaniel Book, the attorney wants to withdraw. He's been hired. The defendant wants him withdrawn. Are you going to have any objections on that?
No, Judge.
All right, so we'll take this hearing up. Mr. Ortman, you need to start your video. All right, the court is calling 2020 CR 3138, State of Texas versus Nathaniel Book. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Ronald A. Ortman as an appearance attorney for Jesus Lopez.
All right, and are you Nathaniel Book?
I am, ma'am.
Do you have any objections to Mr. Ortman standing in for Jesus Lopez?
I do not, ma'am.
All right, the defense has filed a motion to withdraw as counsel. Does anyone have any objection to this hearing taking place by video? State?
None.
Defense?
No, Judge.
Mr. Book, any objection?
No, ma'am.
All right. Mr. Book, your attorney has filed this motion to withdraw. The state has no objections to the motion to withdraw. Are you in agreement with your attorney's request to be removed from your case?
Yes, ma'am.
All right, then the court will grant the motion to withdraw. Mr. Book, can you afford to hire an attorney or do you need one appointed to you?
May I have one appointed, please?
All right, Mr. Ortman, you are excused.
Thank you, Judge.
Thank you. And Mr. Book, I'll need you to remain and we'll see about getting you an attorney.
Yes, ma'am.
Sean Hendrickson, who do you have?
Frank Mathis, Judge.
Criminal Trial Division or Family Violence?
CTD.
All right. And Mr. Hendrickson, when you get a chance, be sure to speak to your client about appropriate dress for court.
I will, Your Honor.
Thank you. I'll see you to number 12.
Thanks, Judge.
All right, David Woodard, you're back.
I am, Judge. We've conferred on Laurel Peterson, and we have a tentative agreement. The state does want my client to take a UA. I'd like to know if she can take that UA first thing in the morning and recall our case for tomorrow morning.
Okay, well, what are the results going to be?
She's telling me they're going to be clean, but they want her to take a UA. She's unable to take it today because she's at work. And she's actually told me she would be late because she had Zoom this morning. So I just wanted to know if she could possibly take it first thing in the morning and recall us for tomorrow morning.
Well, what are the suspicions of drug use? That's the question.
Well, I think she hasn't taken one. So the state wants to have proof that she has a clean one. And then I think our agreement is going to be, with the court's permission, to withdraw the MTR and terminate her probation.
Well, here's the question. I'm looking at my notes. On June 29th, we were supposed to have a contested hearing. The defendant was to provide a clean UA. So what was the UA? Did she do a UA on the 29th?
To my knowledge, Judge, I don't believe so, from speaking with Mr. Hernandez. He's in the breakout room right now with my client.
All right, can you have them both come back to the main room, please? Luis Martinez.
Judge, I conferred with Marcus Sanders. Judge, I think there's a possibility we get the MTR withdrawn, but we need to show compliance on some issues. So we're asking for a short reset to get those things done.
And what issues are you all seeking to?
We need to make sure that that my client is in fact participating in intensive outpatient and that his classes are done. He's being supervised at Harris County, so sometimes there's a communication breakdown.
And how much time are we looking for?
I just need 2 weeks.
All right, Norma, can you recall Mr. Garza for 2 weeks, please?
Yes, ma'am. I can do the 29th, Judge, or the 30th.
29th or 30th? Mr. Martinez.
I'm looking, Judge. The 30th would be good.
All right, we'll see you on the 30th. You and your client are excused.
Thank you, Your Honor.
Thank you.
Judge, I send you a chat.
Okay, thank you. All right, Laura Peterson.
Yes, ma'am.
Did you do a UA on June 29th? Because we were here on June 29th, and it was supposed to be set for a contested hearing on August 11th at 2 p.m.
Yes,
And,
no, ma'am. What, June 29th?
Yeah, and what I ordered, it's defendant to pay towards restitution and provide a clean UA. And you were supposed to do that UA that day, so did you do it?
Ma'am, you didn't say go do it that day. It said 30 days to take a UA. I contacted the lady for payment and the UA. They have to set up.
Let me ask you this. Have you done a UA in June?
No, ma'am.
Did you do a UA in July?
No, ma'am. I haven't did any UA. No one has contacted me.
Yeah.
When I was on probation, go ahead, Judge. I'm not trying to.
No, go ahead.
When I was on probation, I haven't had no contact with anyone. That's what I was just telling the man. I contacted them for the payment information to make the payments you did. When I came to court, no one was there. That's when I got reset. That's my last time being there. I came to court in person and no one was there before this court date. And the lady gave me the new court paper for today. I went in the back of the courtroom.
Now, your court was scheduled for June 29th. Then we were to have a contested hearing on August 11th.
11th in person. And I came in person and no one was in the courtroom.
And on June 29th, you were to provide a UA. So I haven't had a UA from you since June, well, before June, because I asked for one to be provided in June. So June, July, August, no UA from you.
No, ma'am. No, I haven't been to UA. I'm not gonna, but if I wasn't mistaken, in June, I had 30 days to provide a clean UA. I didn't go. Granted, I didn't, because I didn't have any contact with my probation. I haven't spoke to my probation officer or anything. Usually when I go, she'd be like, go take a UA this day. Okay, ma'am, I get there, my appointment set.
Who's your probation officer?
Veronica
Della Rosa.
All right, let's have Veronica zoom in.
Okay, 1 second, Judge.
Thank you. We'll have your probation zoom in. We're going to figure out what's going on.
Yes, ma'am, because when the last time I really even spoke with you, I've been recessed so many times. I spoke with you was in March. You told me, hey, do you want to be extended? And I was like, no, ma'am. You said, go do that to community service, or next time you come to my court, you're not going to come in Zoom, you're going to come in person, and you're going to be extended.
No. Here we are, March 1st. This is when you were here. It was to be recalled for March 8th because there's supposed to be an update on your medical issues.
Yes, ma'am, for COVID.
Defendant to complete community service hours by March 29th.
And I did that.
Or it will be extended.
Yes, ma'am.
March 30th, defendant no show for compliance hearing.
Excuse me, Judge. That's what I wanted to speak on. This is why I got MTR. Oh, sorry.
June 29th. We're supposed to have a contested hearing for August 11th at 2 p.m. Defendant to pay towards restitution and to provide a clean UA on that date. And it hasn't been done. And you haven't done a UA since, well, before June. So here's the thing. We're bringing in your probation officer.
Yes, ma'am.
Mr. Woodard, her probation officer zoom it in, but it appears that she's going to have to do a UA today. Because
Judge, I have to be at work. I'm on probation. I just started a new job. I just told the man in the breakout room, I could go in the morning. That's no problem.
Time out. Wait for probation to show up. Yes, Todd McRae.
Good morning, Judge. We should be ready on a plea. I have Mr. Greenidge here in my office.
All right. As soon as we get the paperwork, we'll go from there.
We're sworn in and everything, Judge.
All right. I'm just waiting for them to bring me the paperwork. Ted Wood on Stribling.
Okay, Judge, it appears that the competency eval has still not been done. If you remember, you probably don't, you got 1,000 cases going. We were here probably 6 weeks ago. The competency eval was supposed to be done that day. It has still not been done. The CLM, Lupe called the CLM, they have it assigned to somebody new. Was assigned to somebody new on the 13th, which is what Mr. Martin told me. There was a new entry in the system on Monday. That was apparently the assignment of the evaluation to somebody new.
All right.
So,
do you know who that would be?
No, ma'am, I do not, Judge. I do not, Your Honor.
Norma, can you check and find out when the evaluation is going to be done on Mr. Stribling?
Yes, ma'am.
Thank you. We'll find out.
Great.
Judge, could you move an inmate?
Yes.
Could you put Soto into breakout room 10, please?
All right, Mr. Soto, if you'll go to breakout room number 10. Thank you.
I talked to the clerk. I don't know what day.
All right. Mr. McCray, and who is the prosecutor on Greenwich?
Marcus.
That's Marcus Sanders, Your Honor. Put that away, Jonathan.
All right, the court is calling 2021 CR 6038. State of Texas versus Jonathan Greenwich. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Your Honor, I'm Todd McCray. I represent Jonathan Greenwich.
And are you Jonathan Greenwich?
Yes, ma'am.
Okay, Mr. Greenwich, I'm going to need you to make sure you speak up because the court reporter is taking down everything that's being said. We're proceeding by video because of the pandemic. Any objection from the state?
None.
Any objection from the defense?
No objection, Your Honor.
Mr. Greenwich, I'm going to show you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video conference. I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, I did review it with my client, and I believe they have complied with the discovery rules.
Court will find that the state is in compliance with discovery. Mr. Greenwich, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we're waiving the enhancement paragraph.
Any objection?
That's part of our agreement. No objection, Your Honor.
Mr. Greenwich, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review this document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felon in possession of a weapon? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, then if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea where you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, ma'am. We've had considerable time to discuss this case and consider his defenses.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that, yes.
Mr. Greenwich, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at a cap of 4 years in the prison. The state will remain silent on your application. The state will take in consideration 2021 CR 6039. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
That's our agreement, Your Honor. Yes, ma'am.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then Mr. Greenwich, to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
Yes, the state offer states Exhibit 1 and its attachments.
Any objections?
Again, which we reviewed in its entirety and find no objections, Your Honor.
Mr. Greenwich, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. How the court will defer finding of guilt as you apply for deferred adjudication. All right, proceeding with sentencing.
Judge, we could proceed with sentencing. We do have some character witnesses court to hear from, and we don't have those available today. But Mr. Greenwich is asking you to grant his application for deferred adjudication. State silent on that, and he would ask the court to follow it in terms of granting the deferred adjudication. But if we need a hearing on the court wants to hear character witnesses, then I would like to be able to present those at some point.
Okay. Then my question for you, defense, is why should I give him deferred adjudication as opposed to a conviction?
Judge, he taking a look here on Jonathan's behalf. We've got a letter from his employer. He's doing really well in the community. He's employed. He's actually had to leave work to be here today.
Where is he employed?
He is employed at Tricon Precast Limited.
Yeah.
And I have a letter here from Spencer Clark.
What does he do there?
You want to tell the judge what you do, Jonathan?
I test concrete for the that separate the highway. I test the concrete and make sure that it's strong enough to stop a car, truck, 18-wheeler from crashing and going to the other side of traffic.
And we have a certificate from the American Concrete Institute where Jonathan is certified to do this. He's the ACI concrete field testing technician. So he's employed, he's responsible. And we had a number of people, somebody from the church and some people from his family that are behind him 100%.
All right, Mr. Greenwich, if you're drug tested today, what are the results going to be?
It'll be positive for marijuana.
Okay, why are you doing marijuana that's just ruining your life? We're trusting you to lay concrete and make sure that 18-wheelers can travel across it, and you're doing marijuana. Is it going to be positive for anything else?
No, ma'am.
When's the last time you used marijuana?
Like this past weekend.
Do you have any children?
Yes, ma'am.
What are their ages?
I got a 15-year-old son. I have a 1-year-old son. and I'm expecting a daughter.
And are these children living with you?
No, I co-parent.
All right, is there anything else, Mr. McCray?
Aside from our chance to put on the character witnesses, we had asked you to go grant him the deferred adjudication. Judge, he's always been here on time. My office, he's always been very respectful. He's been able to bring in verification to my office.
Mr. Greenwich, I'm
attends
going
a
to give you
church. He's certified.
Mr. Greenwich, I'm going to give you a choice. You know yourself better than I know you, better than the state knows you, better than your defense attorney knows you. So I can give you 5 years deferred adjudication. If you are unsuccessful on that deferred adjudication and if a motion to revoke is filed, the court will have the full range of punishment to sentence you. So the court will be able to sentence you up to 10 years. Or I can give you 4 years probation. If I give you 4 years probation, and if you're unsuccessful, the most time that you can receive potentially is 4 years. So do you want deferred adjudication or do you want regular probation?
If I take deferred, will the conviction be off my record if I complete it?
No. Deferred adjudication will show up on your record. Your defense attorney can tell you this. So it will just show up that you were not convicted, but it will show up on your record. So anyone who pulls your record will show that you received a deferred adjudication for this offense.
With deferred probation, will I have an opportunity to get off sooner than 5 years?
You can speak to your attorney about that. I'm always open to whatever anyone wants to present to me.
And we've talked about that, Judge, and we've talked about the deferred adjudication as well.
So which do you want to do?
I have to make that choice right this second?
Yes.
If you want to take a break and come back, or either I can give you 2 years in the prison, 2 years prison, 4 years probation, or 5 years deferred.
I'll take the deferred.
Do you, Mr. McCray, does your client need more time to speak with you about whether or not deferred or regular probation?
Could I just have 1 minute? I'm going to mute just 1 minute, Your Honor.
Yes. David Woodard, could you show your video, please? Mr. McCray, I'm going to give you more time to talk to him. Let me take up another matter, and I'll give you more time to talk to him.
And we're ready, Judge, but we can wait.
Are you sure you're ready to proceed?
Yes, Your Honor.
All right, then, Mr. Greenwich, what would you like to do?
5 years deferred probation.
Okay, and I will tell you, Mr. Greenwich, I don't give choices to everyone because I can't give choices to everyone, but I'm going to see if you're going to do what you're saying that you're going to do. Your attorney has presented information to me that is important for me to make this decision. So I'll give you 5 years deferred adjudication. Take in consideration 2021 CR 6039. You're to provide a UA today. And Kevin, can you make sure that you get his levels? Mr. Greenwich, while you're on probation, you're not allowed to smoke marijuana or drink alcohol. Do you understand?
Yes, ma'am.
And then after that test for levels, Kevin, then he can do regular UAs. Mr. Greenwich, are you able to report by Zoom?
Yes, ma'am.
All right, you're to report, but regular reporting by Zoom or in person. So if something happens to your Zoom and you're not able to report by Zoom, you'll need to report in person. 100 hours of community service restitution. 40 hours of those will be waived if you obtain the COVID vaccine, or if you already have the COVID vaccine and you present proof of that, then the court will deduct 40 hours of your community service restitution. I'm not forcing you to do it. It's strictly up to you whether or not you do it or not. But if you do it or have done it and provide proof, there'll be 40 hours deducted. Proof of employment. within 15 days. There's to be no employment as a home health care provider or any employment involving minors. Random field visits, 1 time per month. And I'm going to order parenting classes. You're going to have to do parenting classes no matter what, but if you complete them, that can go towards your community service hours. Kevin, is there anything else that Mr. Greenwich needs?
Sorry, I was muted. No, Judge. I think that's it.
All right, Mr. Greenwich, is there anything else you need from the court in order to be successful on this probation?
I need custody help. I'm having
This
problems.
is not a court for custody issues.
Oh, I didn't know. I thought you said anything. I apologize.
No,
That I need.
but I tell you what, that one of the key things to obtaining custody is not to be smoking marijuana.
Yes, ma'am.
Because let me ask you a question, Mr. Greenwich. If you needed a babysitter for your children, and let's say I come with great references, I'm the Black Mary Poppins, everybody loves me. You test me out with your children love me. And you say, yes, I want to hire you. You can start today. And then I tell you, let me just give you a little bit more information. I smoked marijuana last night. Do you still give me that job and leave me alone with your children?
No, ma'am.
There we go. So I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And Mr. Greenwich, from here on out, every decision you make in your life, you need to ask yourself, is this decision something that could potentially result in me going to prison for 10 years? You understand?
Yes, ma'am.
All right, good luck to you. I'm going to send you to breakout room number 1.
I just want to verify, was there a fine on that? I didn't hear it.
No, there's no fine.
Got it.
All right, Mr. McCray, if you go to breakout room number 1 and just wait there patiently. And Kevin, before you go, I want to speak with the probation officer that you said is in the room.
Yes, Judge, she should be here. Veronica, if you could show your screen.
Thank you, Your Honor. Thank you.
Thank you.
She's here, Judge.
All right, thank you. David Woodard.
I'm present, Judge.
Thank you. All right, Ms. Carrillo.
Yes,
We're
ma'am.
not on the record as of yet. Ms. Laura Peterson is saying that she's having problems getting in contact with you. When's the last time she did a UA?
The last time I have record is on August 21, 2020.
Okay, is there a reason we don't have, oh, what was the result from August? You say 2020?
Yes.
All right, is there a reason why there are no UAs since August?
She has not submitted a drug test.
Okay, is there a reason why the court wasn't made it aware that this defendant who's supposed to be doing UAs regularly hasn't had a UA since August 2020?
She had the MTR. She was instructed, the last time I spoke to her was on July the 15th of 2021. She was informed that per the court, she was ordered to go for a drug test. At that time, she had told me that she was told to be prepared to submit a drug test, not to submit a drug test. She told me that her attorney did not tell her to do that.
And everything becomes clear. All right, this is the thing, Ms. Peterson. On this case, Mr. Woodard, which attorney are you speaking with?
Me?
I was speaking with Meredith, Judge, for the state.
Okay, let me see where Meredith is. And everyone, please be patient. Just put some patience in your pocket. All right, she's in breakout room number 9. We're going to have a discussion with her. And Ms. Carrillo, could you please remain so we can speak with the prosecutor with her attorney?
Yes, Your Honor.
Thank you.
Judge, and if it helps, just for the notes, because I don't think Ms. Carrillo has that note. The last time she was in court, when it was reset in, I believe, June,
Yes.
Rebecca Reyes was in the courtroom and she instructed her to submit the UA and to catch up on her payments. It appears she did make, I guess, 2 payments in August, but she didn't submit the UAs.
All right, thank you. So we're going to do something with this case today. All right, as soon as
Can I speak, Judge? No one.
now.
Judge, can I see you in a breakout room? If you have time,
Yes.
whenever you have time.
All right, just give me a moment. All right, Bo Wood, Chris Collins.
Yes, Judge, we've started the paperwork. We just need to get him signed.
All right, thank you. And is your client on the Zoom screen?
I don't see him. He's an inmate, so
All right, Norman,
I
can you
don't
give
see him
me,
on page 2.
give Mr. Wood an ETA on Mr. Collins?
Yes, ma'am.
All right, and then John Winter.
Yes, Judge. Can I be put in a breakout room with Gabriel Guerra?
Yes, let me see what breakout room you're in. You're in number 11. Mr. Guerra, go to 11, please. Doug Campbell.
Judge, I've talked with Joe Ray Garcia. It appears that we're going to have to set this for trial. He tells me the first trial date is November 1st.
All right,
And then-
Jess. Did you confer with Ms. Ferguson on that date?
I have not.
Okay.
And Judge, if
Joe
I
Ray,
need to talk with Ms. Ferguson, can I do that later? I'm about 15 minutes late for another setting in CPS court.
No, just give us a moment. Joe Ray, did you speak with Ms. Ferguson on that November date?
No, not on this case, Judge.
All right. And it's Roland Signs, correct?
Yes, Judge.
But Joe Ray, you're okay with the November 1st date?
Yes, Your Honor.
Okay.
Hopefully we can resolve it for that date, but we'll see.
Oh, no. Once this happens, the plea deadline dates will have expired.
Oh, no, I'm not talking about a plea deadline.
Okay. All right. The court is going to call, just one moment. The court is calling 2021 CR 4555, 2021 CR 4556, State of Texas versus Roland Signs. Could I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Judge Doug Campbell for Roland Signs, who's in custody.
All right. We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No.
Are you Mr. Signs? Could you unmute, please?
Yes, ma'am, I am.
All right, we're proceeding by video. Any objection, Mr. Signs?
No, ma'am.
Defense, have you received all the discovery in this case?
I have, Your Honor.
And that's in both cases, correct?
That is yes, in both cases.
All right, to the state, the court does not have an acknowledgement of discovery in the court's file in either of these cases. State, are you able to provide an acknowledgement of discovery by October 1st?
Yes, Judge.
All right, acknowledgement of discovery will be due October 1st in each of these cases. Mr. Campbell, was an offer tendered?
It was, Your Honor.
Mr. Signs, are you rejecting the offers that were tendered in each of these cause numbers?
Yes, ma'am.
Are you requesting a jury trial?
Yes, ma'am.
State, defense, it's the court's understanding that you both conferred over a jury trial date. State, any objections to November 1st as a jury trial date?
No objections.
Defense, any objection to November 1st as a jury trial date?
No, Your Honor.
Mr. Sines, any objection to November 1st as a jury trial date?
No, ma'am.
All right, then, Mr. Sines, your jury trial date will take place November 1st at 9 a.m. in the 187 District Court. The courtroom is located at 300 De La Rosa on the 4th floor. Do you understand?
Yes, ma'am.
When is your court date?
November 1st,
And what courtroom?
187.
All right, and you will be brought over dressed for trial if you are still in the Bexar County Jail. If you're not at the Bexar County Jail, you will need to come to court dressed. Do you understand?
Yes, ma'am.
And Mr. Sines, in each of these cases, your plea deadline has expired. The court will not accept any plea bargain agreements. If you decide to enter a plea, then that plea will have to be open to the court. Do you understand?
Yes, ma'am.
All right, if there's nothing else, the record is closed. Norma, can you let them know that L7 can go back, that Sines?
Yes, ma'am.
And then Norma, on Ted Wood's client. Oh, Mr. Campbell, you're excused.
Thank you, Judge.
Thank you. On Ted Wood's client, do we have an update on the compliance? Mr. Stribling, yes, there's something you wanted to say?
Yes, ma'am. I did the mental and competency exam the same day I went to court. They called me. I left court and then I went back and spoke with Dr. Jumis the same day that I had court the last time.
Oh, so you've already been evaluated? Is that what you're telling me?
Yes, ma'am. And he's contacted my mom and he's contacted Sarah Herring in the matter. And I've already spoke to Dr. Jumis.
Okay, then what we need is, Ted, we're going to do a short reset for him. And Ted, if you could check with Dr. Jumis to see when he would have his report done.
Very well, Judge.
All right, let me give you a new date. Just one moment. Okay, Norma's on the phone. Let me look at the calendar. All right, let's do October 13th. If there's an issue with that date, yes, Mr. Stribling.
If possible, if I could speak to my attorney in a breakout room, just to, because I mean, I would like to get out of jail, and then if it was possible to speed up without the incompetency exam and to do all that, but I mean, like if I could just speak with him about that matter.
Well, it depends on whether or not your attorney wants to withdraw the motion for competency. So, Mr. Wood, I'm going to send you to breakout room number 8.
Very well.
Mr. Stribling, if you can go to 8, and then
Yes,
we'll
ma'am.
come back, Mr. Wood, and we'll come back and get a date for you.
Judge,
Very
can I see you in a breakout room, Judge?
Yes. Number 1.
Thank you.
Mhm. All right, Meredith, could I speak with you and David Woodard on Miss Laura Peterson, please?
Yes, Judge.
All right, and Meredith, if you'll go back to number 9, and David Woodard, if you'll just come to number 9. And everyone just give me a moment. Please put some patience in your pocket. It's still Wednesday. And Ted Wood, just give me a moment with your person.
Very well, Judge.
Ms. Carrillo, if you could come to number 9 with us, please. All right, Ted Wood.
Yes, Your Honor.
Yes, so with Mr. Stribling.
Judge, At the request of Mr. Stribling, my competency eval request has been I'd like to withdraw that or non-suit it. However, the court wishes to phrase it or characterize it. And he wants to move forward on the offer from Mr. Martin, which I can put on the record for you, or we can just start the paperwork, whichever.
You can do the paperwork and then we'll put on the record about the competency issues.
Very well, Judge. May I ask you please to put me in a room with Mr. Martin?
Yes.
Very well, Judge. Thank you.
You're welcome. Ted, if you will go to breakout room number 2, please.
Very well, Judge. Thank you.
And David Martin, if you can meet Mr. Wood and number 2, please. All right, Alfonso Cabanas, who do you have?
Good morning, Judge. I have Mr. Adrian Garcia. It's a family violence case.
I'll see you to breakout room number 3.
Yes, Your Honor.
All right, Claudine Espinoza.
Good morning, Your Honor.
Good
I
morning.
conferred with Mr. Garcia,
Yes.
and he is okay with the reason that we're asking to modify bond conditions. She's currently living with her father right now, and she just wants to change her address to her mother's address and live with her mother.
Okay. And I'm assuming her mother's aware of this and her mother's in agreement?
Yes, Your Honor, she is, and we've provided the address where she's residing now and where she will be residing.
All right, then. Thank you so much for coming in. You are excused.
Thank you very much. You have a good day.
All right, thank you. You too.
Thank you.
We also, remember, Claudine, we wanted to address, or I guess she's going.
What did you want to address, Ms. Dottie?
A month ago, we had court with you when we had changed from my GPS monitoring from full house arrest to partial, and then you had also said that in a month, so on the 13th of this month, it would be that we.
All right, so what you'll need to do, Ms. Dottie, if you can zoom off, contact your attorney, and this will be the same link if she wants to zoom back in, and she'll need to discuss that with someone from the state.
Okay, thank you.
You're welcome. All right, Jonathan Watkins.
Good morning again, Judge. I conferred with Mr. Morris. We tentatively have like a plea arrangement that's going to take care of this case and a misdemeanor case. I'm going to talk to my client after this hearing. And if I could just get 2 weeks, Judge, if we work out the misdemeanor, it would take care of this case. So I just need 2 weeks to see if I can make that happen, Your Honor. And
All right, which court is the misdemeanor in?
I believe it's in County Court 9. It's Judge South Court.
All right. Oh, I'm sure that will be, she'll give you a date soon on that. All right, Norma, on Richard Garza, can I have a 2-week reset, please?
Yes, ma'am, I can do the 30th.
All right, we'll recall it on September 30th.
Yes, ma'am. And thank you, Judge. Thank you, Norma. And my client and I be excused for today, Judge?
Yes. Have a great rest of your day.
You too, Judge. It's almost Friday.
It is. Okay, Vivek Jampala.
Yes, Your Honor. I think the attorney for the state and I are hashing it out, and I was gonna ask for a 30-day reset. I apologize. My client isn't here. I wasn't able to give him the information to get here in time, in a reasonable time for him to make accommodations. I only realized the setting was happening this morning, and I apologize for that.
Okay, well, today is for discovery issues. So are there discovery issues?
We have a couple, but I think in 30 days time we can
Judge,
get
we're
closer
still
to a resolution.
we're still working on that, but I will say that there has been a new offer tendered, and so we're kind of doing both at the same time.
All right, Norma, can you give us a 30-day reset on Mr. Nathan Gomez, please?
Yes, ma'am. Give me 1 second.
Okay, I say Nathan, but I think it's pronounced Nathan.
Yeah, that's correct, Your Honor.
Sorry.
No worries.
I can do the 20th, Judge.
All right, we'll come back on October 20th. Your client will need to be here.
All right. Thank you so much, Your Honor.
You're welcome.
Have a good one.
Thank you. You too. All right, Sean Hendrickson.
Morning, Judge. I'm here on Frank Mathis.
Yes.
And so I conferred with the state and we are asking for a reset on this case.
Let me see what page he is on.
I'm not entirely sure that he got put on the docket this morning, Your Honor. I saw him on the county site, had him for today, but I didn't receive an email. And when I looked at the docket, I think he may not have been on there. So.
All right, because I don't have him on the docket as well. To the clerks, could I have the file on Frank Mathis, please? Mathis. And Norma, on Nathaniel Book, do we just need to reset this and let him know who his attorney is?
Nathaniel Book?
Yes. Derek
Judge,
Edmonds?
he said he'll log in 30 minutes, Judge. I send you a chat.
All right, thank you. To the clerks, could I have the file back, please, on Nathaniel Book? All right, Mr. Book, your attorney will be zooming in shortly. All right, David Woodard.
Yes, Judge, I just want to know if we can be excused until tomorrow morning.
Yes.
You can leave, Laurel.
And Norma, on Laura Peterson, that's coming back tomorrow.
Yes.
Judge, can we excuse Ms. De La Rosa?
I'm sorry?
Can we excuse the probation officer?
Yes.
Thank you.
Thank you.
Thank you for coming in. And John Winter.
Could I go back in the breakout room with Meredith and David if he's available?
Yes. Let me see where you were. I'll send you to breakout room number 2.
Thank you.
And if David and Meredith could go to 2, please. Ted Wood, you're back.
I am back, Judge. David, Mr. Martin and I have conferred under 46B sub 004. Once the evaluation has been requested, it must be completed. So I think that what I need to do is give Angela or Hector or somebody a ring and get a date set in the criminal law magistrate court.
Just one moment. All right, Norma.
Yes, ma'am.
Can you see when that they can have this set in Judge Carruthers Court to actually hear this? Because what I'm reading from the code, yes, it has to happen. But if there's evidence presented that there is not a need for competency, then that's something maybe Judge Carruthers could hear.
Yes, ma'am.
And you can have it set and maybe a doctor can come in and examine him in the courtroom.
The judge, he's been examined by Dr. Jimis.
Okay.
It did in fact happen the way that we thought it was. We were in court on the 25th of August. And he came in and actually examined him later that day.
Yes. So Norma, can we set this and call Judge Carruthers Court and see when they can have this set? For someone to get in touch with Dr. Jumis?
Yes, ma'am.
And then Sean,
Yes,
on
Judge.
Frank Mathis, we're here today for, you're right, it is set today, and it's set today for discovery. So
I don't think we have any discovery issues at the moment, Your Honor.
Right, well, have you received all the discovery? Because that's why it was reset.
Yes, I believe that I have.
Okay, so where's these cases heading?
Well, we have the framework of an offer right now, Your Honor. So I need to discuss that with my client, and I think that we've got a little bit of work on our side left to do too. So we won't have an agreement this morning, Your Honor, but we'll have a better idea by the next setting.
All right, we'll recall it for October 20th.
October 20th, Your Honor?
Yes.
I will be out of town that week, so from the 19th to the 25th.
Okay, just 1 second. Norma, can you reset Mr. Mathis? She's on the phone. All right, then let's put it for October 27th. If that's not a good date, she'll let us know later.
Okay, that'll work out for us.
All right, see you October 27th. You and your client are excused.
Thank you, Judge. You have a great day.
Okay. Thank you, you too. All right, Ted, we're getting a date on your guy. Just give us a moment.
No problem, Judge. Thank you.
You're welcome. Alfonso Cabanas on Adrian Garcia.
Good morning, Judge. I confer with Joe Ray, and we selected a November 1st trial date.
I need to see your video, please. Thank you.
Yes, Your Honor. Mm-hmm.
All right, the court is calling 2020 CR 4632, State of Texas versus Adrian Garcia. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Alfonso Cabañas.
And are you Mr. Garcia?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No objections from defense, Your Honor.
All right, Mr. Garcia, do you have any objections to us proceeding by video?
No, ma'am.
Defense, have you received all the discovery in this case?
Yes, Your Honor.
Court will note for the record that the court has a discovery acknowledgement signed August 3rd, 2020. Has an offer been tendered?
Yes, it has, Your Honor.
Mr. Garcia, are you rejecting that offer?
Yes, ma'am.
Are you requesting a jury trial?
Yes, ma'am.
All right, your jury trial date will be November 1st at 9 a.m. in the 187 District Court. The 187 District Court is located at 300 De La Rosa on the 4th floor. You will need to come dressed for trial. If juries are still suspended, your attorney will be made aware. Do you understand, Mr. Garcia?
Yes, ma'am.
When is your court date?
November 1st,
What time?
9 o'clock in the morning,
And what is the courtroom?
187.
All right, your plea deadline date has expired. What that means is the court will not accept any plea bargain agreements. The court will only accept pleas open to the court. Do you understand?
Yes, ma'am.
All right, if there's nothing else, Mr. Garcia, you and your attorney are excused.
Thank you, Judge.
Thank you. All right, Kelly McGinnis.
Hey, Judge, I'm here for Keith Evans. It was a motion to set a bond. I filed it yesterday. I came in person and dropped off a copy that was a file stamped copy. My client's not here. I think it is family violence, but it's an unindicted case and he does have a warrant, so I can't look it up. Maybe I could confer with David or something.
All right. The cause number state is CM087512. Does anyone know, is that criminal trial division or family violence? Because there's it's an aggravated assault with a deadly weapon.
Yeah, one more time, Judge.
CM087512.
Keith Evans.
Yes.
Aggravated assault. Looks like it does not have a unit assigned. Whether or not that's because it doesn't need a unit assigned or it's too early in the process, I'm not sure.
All right, Ms. McGinnis, I'm going to send you to breakout room number 2 and a prosecutor will meet you there.
Hey, Judge.
John, you're welcome. John Winter.
Yeah, Judge, we have, well, we don't have agreement, but we have agreement to plead true on Gabriel Getter's MTR. So I just chatted Norma to send me the certification, and once I get that, if I can be put back in the breakout room with Gabriel, I'll go over it.
All right, I'll send you to number 11. That's where your client is. Matthew Allen.
Yes, Judge.
Yes, what is happening on Soto?
We worked it out. We are getting the paperwork ready.
All right, thank you. And Norma on Stribling?
Yes, ma'am.
When are we coming back?
They didn't give me a court date, Judge. They said they were still waiting for Martha to get back with them on the court date. They said they couldn't give me a court date from Judge Carruthers' court.
All right, Ted Wood, we're going to give you a 30-day reset. If it's taken care of before then, just let us know and we'll put him on the docket before then.
Judge, is there any way that Mr. Stribling can be released today on, I filed some motions for bond reduction. He's got child support issues. He's got a number of different issues. He's got one bond that's in place, one bond where an affidavit of surety to surrender has been filed, which is the dope case. And I filed for a request for bond reduction on the VPO, Judge.
Right, so you can confer with the state on that. Let me get this date for you first, and then I'll let you confer in the state and we'll see if they're ready to proceed on that. If they're not ready to proceed on that, we'll bring him back before this date.
Great, thank you. Judge.
Yes.
October
Appreciate it.
20th, Judge.
All right, so you're welcome. So Ted Wood, it's going to be October 20th. Mr. Stribling,
Yes, Your Honor.
if everything is taken care of with your competency before that date, your attorney will let us know and we'll bring you back sooner.
Yes, Your Honor.
All right. Let me just rename you. All right, and David Martin, if you could see Ted Wood, please, in breakout room number 3 of our bond issue.
Thank you, Judge.
Derek Edmonds, your client is Nathaniel Book. And it's criminal trial division. Would you like to speak with somebody from criminal trial division first, or your client?
Judge, I was just appointed on it this morning, so I don't even know anything even about the case. Normal indicated that you wanted me to log in just to visit with the client this morning, so I'd rather just visit with the client. I'm not sure visiting with I can visit with the state and get an offer from them, but I don't even know anything about the facts of the case except what the charge is.
Okay, Norma, can you give them a 30-day reset on Mr. Book, please?
Yes, ma'am, October 20th.
All right, Mr. Book, we're going to come back on October 20th. I'm going to send you to a breakout room with your attorney and Mr. Edmonds. You all can be excused from that room. However, if you want to speak with the state, Mr. Edmonds, just come out of that breakout room.
All right, thank you very much, Judge.
You're welcome. I'm going to send you out to breakout room number 4.
Okay, great. Thank you.
You're welcome. And Mr. Wood, thank you so much for your patience. We're waiting for the jail to bring your client over.
Thank you, Judge. Not a problem.
You're welcome. Norma, is Hernandez being reset?
Yes, ma'am. I will put the date in the chat, Judge.
All right, Kevin, on Michael Hernandez, that's being reset for September 23rd.
Michael Hernandez.
Yes. Ted, your client is here. Bo, your client is here. So I will
Thank you,
send
Judge.
you
Good.
to breakout room number 5, and I'll send Mr. Collins to 5.
Thank you.
You're welcome. Norma, what is happening with Gregory Oliver?
Mr. Sandoval said that he is in another court. He'll be here shortly. He said he'll be here soon, Judge.
And on that one, on Oliver, do we have an update on the competency, Norma, on Oliver?
I'll check right now, Judge.
All right, thank you. Yes, Mr. Winter.
Judge, we signed the paperwork, so we should be ready to go as soon as you have it.
All right, I have just received it, so I'm signing it now.
Can you hear me now? It's almost 11 o'clock. Okay, my bad. I was,
And to the clerks, I'm going to send you to a breakout room to swear in Mr. Soto.
Thank you, Judge.
And let me see where Mr. Soto is. He's in number 10. And there should be paperwork coming back on Guerra.
Okay, thank you.
Who's the prosecutor on Gabriel Guerra?
That was Meredith, and I think she just, oh, there she is. She's there.
Yeah, I'll be doing it, Judge.
All right, thank you. Brenda, you know what I learned? Once you get people in the spotlight, just never remove it.
Yeah.
All right, the court is calling 2019 CR 11686, State of Texas versus Gabriel Guerra. Can I have parties announced for the record, please, for the state?
Meredith McIntyre for the state.
For the defense?
John Winter for the defendant.
All right, and are you Mr. Gabriel? Could you unmute for me, please?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Guerra, did you sign a document entitled Defendant's Consent to appear by video conference? Did you review that with your attorney and did you understand it?
Correct.
I'm sorry?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney and did you understand them?
To revoke probation?
Yes. Did you review those two documents with your attorney and did you understand them?
I don't think I reviewed those. No, ma'am.
So you did not review the document that is the motion to enter adjudication of guilt and revoke community supervision. You didn't review that document with your attorney?
I was, I believe, misinformed because I was believed he said give him my chance to speak on the probation because
No, where we are in the process right now, Mr. Guerra, let me explain to you the process. The process is I ask everyone if they're okay with proceeding by video. You said
Okay.
you're okay with that, right?
Yes, ma'am. Yes, ma'am.
The next question I have to figure out is, are you the same person who's on probation? The reason we're here today is because you're on probation.
Okay, I get you. Sorry, ma'am.
So I'm asking you, this document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, did you review that with your attorney?
Correct.
No, that's not correct. That's either yes or no.
Yes.
Then the state's motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review that with your attorney?
That one, no, ma'am. I don't think I did review that one.
All right, I'll send you to a breakout room. Mr. Winter, did you have a chance to review that with your client or no?
I did, but I'll be glad to go back over it with him.
Sorry.
Oh, no apologies necessary. I want to make sure that everybody knows what we're here for. All right, I'm going to send you to breakout room number 12. Your attorney will discuss this with you.
Yes, ma'am.
You're welcome. Mr. Guerra, you need to go to breakout room number 12.
Let me ask the guard. So.
Sure. Brenna, it's Wednesday. It's a great Wednesday, though. Brenna, I don't know if it's going to rain or not rain. It's very cloudy outside.
It is.
Are you ready to proceed?
Yes, Judge.
Yes, ma'am.
Okay, that's fine. So I just wait here. I just wait here, right? Oh, okay, I got you. Hold on.
Your Honor, I did notice the state is probably going to have to ask for a oral motion to amend because I think there's a grammatical error on one of the ones I'm about to read. I don't imagine that'll be a problem with Mr. Winter.
All right, so which one?
On the motion to enter adjudication,
You can take that.
number 5, it says, did then and there fail to, and then it just has orientation. So I can only assume that they meant to put failed to attend. So I'd be adding the word attend.
That's correct.
Okay, sorry, I just noticed that.
No problem.
We have no objection to that, Judge.
All right, we're back on the record in cause number 2019 CR 11686, State of Texas versus Gabriel Guerra. Mr. Guerra, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
State, are there any motions with regards
Yes.
to those documents?
Yes, Judge, on the motion to enter adjudication of guilt, we have an oral motion to amend the first condition, number 5, to add the word attend before orientation.
Any objections from the defense?
No, Your Honor.
All right, Mr. Guerra, are you the same Gabriel Guerra who's placed on deferred adjudication in 2019 CR 11686 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on September 29, 2020 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
On or about the 29th day of September 2020 in Bexar County, Texas, the defendant, Gabriel Guerra, did then and there fail to attend orientation at the Bexar County Community Supervision Department in violation of condition number 5.
How do you plead to that, true or not true?
It is true, Your Honor, but
No, I didn't. You will have a chance to do whatever explanation you want to do. Right now, I just need to know if it's true or not true. Do you understand, Mr. Guerra?
Yes, ma'am.
Right, so that allegation number 5, is it true or not true?
True.
State?
And then reading from the supplemental motion, in Bexar County, Texas, the defendant, Gabriel Guerra, did then and there fail to report to the supervision officer as directed for the months of November 2020, December 2020, and January 2021 through June of 2021 in violation of condition number 5.
How do you plead to that, true or not true?
True.
State?
State will waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Guerra, did you understand by pleading true to violations of conditions 5 and 5, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations of conditions 5 and 5?
Yes.
Court will find 5 and 5 true. Is there an agreement?
We do not have an agreement, Your Honor.
State, what are you requesting?
Your Honor, the state's asking for revocation. The defendant was placed on community supervision and has done nothing since. And so at this point, we don't feel like he's taken it seriously. And the only reason he is taking it seriously is currently in custody. And so we're just asking for revocation. We do not have a deal. And unfortunately, he does have a pending case. We can't go forward at this time, but we're not in a position to dismiss it at either.
All right, Mr. Winter.
Yeah, Judge. So after talking to Gabriel, he pointed out that he was on bond. His plea and placing on community supervision happened over Zoom, just like we're doing here today. He did meet with the CLO on Zoom, but what he tells me is that he gave him a cell phone number that he had that really wasn't his, but it was a number that of a phone that kind of belonged to a friend of his. So once that friend got the phone back, Gabriel didn't have a phone of his own. He also gave the probation officer his grandmother's landline, but apparently his grandmother is not really the best at giving him messages, and so she never told him if probation attempted to contact him or anything. He also gave probation a email of his, but being somebody who really doesn't rely on email, and since he didn't have his own cell phone or computer or anything, he really wasn't focused on that. And if they did try and contact him through email, which they certainly may have, he didn't have any way to check it to see if they had contacted him. And so, being released, he just kind of just went through life, without looking back and seeing, who's trying to contact me, what are they trying to do? And so he just kind of continued on his life. I don't think that he is.
Mr. Winter, I'm sorry to interrupt, but if you could make sure that you address the issue that when he was granted probation, he was instructed by the probation officer to report to the probation department so that he could be entered into the system. So whether he has a phone or not, or somebody to call him, he was instructed to appear. So I want to find out why, when he was released from custody, he didn't go to the probation department.
Well, I'll let him address the actual specifics. I think he'd be best to do that. I do also want to point out, though, that, he does have a job waiting for him. He's got a place to live with. His father has a house that he can live in. And he can successfully complete deferred adjudication if given the chance. Unfortunately, with COVID and everything and the way that, these Zoom hearings go, sometimes, these kinds of things happen, and he really wants the chance to successfully complete deferred adjudication, keep this felony off of his record. And as far as those questions, I think he's ready to answer any questions that the court has.
All right, can you raise your right hand for me, please? Mr. Guerra?
Yes,
You
ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record, please.
Gabriel Guerra.
All right, defense, any questions?
Judge or Gabriel, so you heard what the judge was asking. What she wants to know is, the usual thing that happens is, after you enter into a plea and after the judge places you on probation on these Zoom hearings, you go into a breakout room, you talk it over with the court's probation officer, and they tell you what to do next. So the judge wants to know, what did that court liaison officer know or tell you, and what did you do with that information?
Last I remember is they did send me an email while I was on the Zoom to go attend the orientation. But after I signed all the paperwork and sent it off, I had to return the phone. And after that, I didn't have any contact with my friend again that had the phone. So I couldn't get it, the date on the email to go for orientation.
And so, if you're given another chance by the judge,
yes,
how can you assure the judge that you will do what you need to do? Take this seriously.
Well, first and foremost,
all that.
I mean, I do have a job waiting for me out there. I mean, I do have a house to stay at. I will be, of course, home, so they can contact me on the landline, and then I will give them the address and the phone number of my boss where I am employed.
Let me ask you, is this the same landline that you gave the court the last time?
Yes, correct. But I can also get a phone from my father has an extra phone that he can let me use. So
you would agree that it's probably a good idea to have
yes, but
different phone.
yes, but until I get out, I mean, I can't purchase a phone. So until I get out, I will be able to provide the new number that y'all can contact me at.
Okay, so this kind of goes back to what I was saying, Gabriel.
Yes, sir.
How can you give assurance to the judge that you're going to put things in place that are going to keep you in contact with probation, keep you in contact with the people who need to be able to communicate with you?
First and foremost, like I said, if given the opportunity, a second chance to be back on probation, I mean, I don't want to be incarcerated. First and foremost, I mean, other than that, I mean, it was my fault. It very irresponsible for me not to pursue, like, even try to like call probation on my behalf. That I take responsibility on that. But I really don't want to be incarcerated.
Well, let's assume that the judge keeps you on probation today. Okay.
Yes, sir.
What phone number will you give probation so that they can contact you? Now,
that'll be the landline.
You have another case that you have to make bond on, but let's say that you are released today. What phone number will you give probation so that they can contact you?
That'll be the landline and my grandmother's cell phone that she has on her.
That the landline? Is that your father's landline?
It's my father's house, but the landline is under my grandmother. Yes.
Okay, so you have two numbers, both belonging to the grandmother, who didn't, give you the messages before, right? So, how can you make things different? How can you get your grandmother to give you messages? Is there a way that you can,
well, because she's
always
how
important this
Okay,
is?
hold on. I can only take one of you. There's a lot of background noise, so I can't hear your full question.
Okay, so Gabriel, that brings up a good point. We can't talk over each other, okay?
Okay.
Okay, so you have to wait until I'm done, okay? And I'll wait until you're done.
Yeah, that would be a question.
Okay. So my question is, can you?
I don't mean to interrupt, Mr. Winter, but I think if my client could be muted, he's 187 Collins. If he could be muted, that will help y'all.
Thank you very much.
Mr. Wood, always willing to lend a helping hand.
All right, Mr. Garrett, can you unmute yourself, please?
The investigator was saying something
Okay.
about that last time, but
I think that's Mr. Guerra's. The background noise is there, Mr. Guerra's, but
yes,
he's out on bond.
That's okay.
Everyone just speak up louder, please.
Yes. So again, Gabriel, what assurances can you give the judge? I mean, what are you going to tell your grandmother? Are you going to tell her how important this is, how important it is that she convey messages to you?
No, actually, she has a cell phone that she carries on her. The landline is the one but the court doesn't have her cell phone number.
So you can give the court her cell phone number, and that's
correct,
one
and that's the one I can use because it's a cell phone. So I'll have it on.
More reliable.
Yes, sir.
Okay. You're also going to have to pay attention to your emails, right?
Yes, but with her phone, I can log on to my email.
Okay. And you're also going to have to get your own phone ASAP.
Oh yes,
correct?
Yes, sir. I mean, if I do get the opportunity to get out, then I will purchase a new phone and provide that information to the court.
Okay. So let's talk about where you're working. Where are you working at?
I work at a convenience store as a maintenance. So I basically do all the remodeling because he has like 3 stores, and then he has 4 family members that have stores as well that they want me to renovate the stores.
And that's a full-time job?
Yes, sir.
And how much you make?
Depending on the job that I'm doing, I have to quote them on that, but I do get paid by the hour, $10.50, just as stocking and cashier. That's just on the regular, but if I do the renovation jobs, and then I quote them because I'm a contractor as well. I know I've worked construction pretty much after high school. So, I mean, that's where I earn my most of the money.
Okay. And so you will be able to afford a cell phone.
Yes, sir.
And you will be able to afford to help your father out with bills and everything that needs.
Yes.
Okay. I'll pass the witness, Judge.
Right?
Just a couple of questions, Judge.
Yes.
Mr. Guerra, do you remember on December 5th of 2019, you failed to appear to court and was remanded, and then you were picked up in March of 2020?
Yes,
Do you remember that?
Yes, ma'am.
Yes or no?
Yes.
Okay, so this issue you're having with probation is not the first time you failed to appear when you needed to, based on this case, correct?
Yeah, I didn't understand the question. You repeat that?
I'm saying the issues you're having with your probation on this case, it's also not the first time you failed to appear on this particular case.
Yes, ma'am. But I was.
If we can just stick with yes or no.
Yes.
And then also on the failure to appear, you realize it was almost a year. You had a year to get in contact with probation, not just the first day you were placed on deferred in September. And you're saying you had no way to reach out to anybody for an entire year?
I mean, well, I really, the pandemic happened, so I really did. I heard that the probation was shut down, the courts were shut down, and I mean, I really didn't pursue it after that. Like I said, I mean, I take responsibility on that. I mean, I didn't.
And so this court has no way of knowing if you were even using at all in the last year because you weren't submitting to any
yes, sir.
tests or anything like that, correct?
Mm-hmm.
No, but you're my defense.
And then also, just to
That's
clarify,
my issue with it.
you understand that you're the one on probation, correct? Not your grandmother or your dad. It's your
Yes, ma'am.
responsibility.
I would
Yes, ma'am.
assume, I mean, just from experience.
Okay, no further questions, Judge.
So long that you would get the.
All right, any
discovery,
follow-up,
analyze it,
Mr.
and come
Winter?
And tell me what is in there.
No, Your Honor.
Uh-huh.
All right, the court will grant the motion. The court will find you guilty. Mr. Guerra, no one knows where you have been for a year. So we are where we are now. And where we are now is the court is going to grant the motion and the court will find you guilty. State?
Yes, Your Honor.
What are you requesting?
Your Honor, at this point, the state's requesting for 2 years.
All right, that is the minimum sentence.
I would never do that too. I mean, just in general, period.
Correct, Judge. He does not have a long criminal history, so the state believes that's fair in this regard.
All right. Defense?
Judge, even, of course, he's trying to avoid the felony conviction, but even with the conviction, I think Gabriel would rather be placed, and correct me if I'm wrong, Gabriel, he would rather be placed on regular probation than be sentenced to prison. But Gabriel, I want you to understand what just happened, all right? So the judge has convicted you of this possession of a controlled substance, all right?
Okay.
But she hasn't decided yet what's going to happen to you. The state is recommending 2 years TDC. So what is it that you would like?
I would like to be placed on probation. So
Here's the
on
thing,
regular
Mr.
probation.
Guerra.
Yes, ma'am.
Nobody likes being at the Bexar County Jail. Nobody wants to be in prison. Your attorney doesn't know you as well as you know yourself. The state doesn't know you as well as you know yourself. I don't know you as well as you know yourself. You need to be truthful and honest with yourself. The fact that you were placed on deferred adjudication and you didn't report and nobody knew where you were for an entire year. How old are you?
I turned 30 in June. So
right. So
30.
It's not like you're an 18-year-old or 17-year-old. You knew you had to report. You're just out in the wind. I'm assuming thinking that maybe if I don't report, then nobody will know I have to report and I'm just going to be out in the wind. So being honest with yourself, you knew you had to report.
Yes,
and you
ma'am,
just chose not to.
I mean, it was during the pandemic, so I didn't.
Nope,
Yes,
don't do pandemic.
I'm not.
with me.
I'm not.
People
I'm
are going to be
not,
doing pandemic.
I'm not.
10 years
I was
from
just
now.
saying.
Mr. Guerra, we're
Yes,
going to, I imagine if I'm still on this planet, 2024, people are going to say, well, you know, the pandemic. Well, you know, the pandemic. People act as though they don't know how to pick up a phone. They don't know how to call probation. And then you gave testimony and you said, well, I heard that probation wasn't allowing people to come down. So that means that you were questioning people and you knew that you had to report and you chose not to.
Yes, ma'am. I accept
Because
responsibility on
you
that.
said, and if I'm wrong, correct me. You said, I heard
Yes, ma'am.
that probation
crazy because I just feel like
was not accepting people to come in. That's what you said. You said you heard. So that means that you asked, unless you're just running around with a bunch of people who out of the blue at a dinner party or at some house said, oh, by the way, did you hear that probation is not letting people report? So that means that you knew and you asked and you chose not to.
Okay.
Yes, ma'am.
Like
I would just ask to be given a second chance to show that I can successfully complete probation.
But no, let's get back to the point. And the point is, you knew you had to report and you did not.
Yes, ma'am, I did.
And you knew how to report and you did not.
Yes, ma'am, I did.
So people need to start being honest. And I'm sure your attorney will tell you when you're throwing yourself on the mercy of the court. I've been a defense attorney, I've been a prosecutor. I would always tell my clients, if you're throwing yourself on the mercy of the court, you need to be truthful. And you need to give something for me to work with.
Yes, ma'am.
So you've come to the court today and been dishonest. And now you're asking to throw yourself on the mercy of the court because you don't want to be at the Bexar County Jail, which nobody wants to be there. You don't want to go to prison, which nobody wants to be there. So let's start from a place of honesty and start answering questions honestly. Do you understand?
Yes, ma'am.
Mr. Winter, do you have any questions?
No.
I don't remember that. I have to go through the court.
So, Mr. Guerra, it just seems to me like you don't want to be on probation. That's where I'm at. You tied my hands. You knew you had to report and you didn't. I don't know what you were expecting to come of this.
Well, yes, ma'am. I do accept responsibility that I was being irresponsible. I mean, I'm being truthful at that. But other than that, that's all I can really say.
He's the one that bonded me out and he was
So here's the question. If it's not you, Gabriel Guerra, if it's just some guy that you don't know who's on deferred adjudication and they never report, they know they're supposed to report, they don't report, what do you think they deserve?
Because is he still on my case or is he not? I don't think he is. He shouldn't be. When I got here,
everyone deserves a second chance, Your Honor.
Nope. Well, see, you were given a second chance. Your first chance was you were on bond and you never showed up and a bond forfeiture was issued. Then you were placed on probation and you never showed up. So we're on chance number 3 or 4 right now. And I'm not talking about you. Come out of your thinking it's about Garrett. If it's just a regular defendant, somebody you don't know, it's not you. Let's say it's me. I'm placed on probation and I don't report for a year. What should I get? What should Brenna get if she's on probation and she doesn't report for a year? What should John Winter get if he's on probation and he doesn't report for a year? Or Meredith get? She's on probation for a year and she doesn't report.
If I may interrupt, I think I should get a stern talking.
Thank you, John. But that's where you are. So you come to me and you're asking for something and your track record shows that you wouldn't be a good candidate. You're not a good candidate for probation. That's where we are.
I would just ask for another chance, Your Honor. I mean, I really don't have
and they inform me you cannot take this program because
I really don't know how to answer that question that you threw out there.
I mean, there really is no answer for it. You're just not a good candidate. I could see if you were young, 17, maybe you're 17, 18, you don't understand. But I know when I place everyone on probation, I always tell them, every decision you make from here on out, Whatever time they could potentially be looking at, I tell them, you need to ask yourself, is this something that could result in me going to prison for 10 years? So what I'm going to do is I'm going to sentence you to 2 years in the prison. I think that's a generous offer. That's the minimum. Getting credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes.
All right, Mr. Guerra, good luck to you.
Thank you.
You're welcome.
One more thing, if you can, please.
Could we be excused, Judge?
Yes, Norman, can you let them know that 14H can go back?
Thank you, Judge.
You're welcome. Kelly McGinnis, do you have an agreement on your case? All right. Then who is the attorney on Bertram Wood's case?
Hunter Morris, Judge.
Yeah, Mr. Morris.
Judge, the
Mr.
defendant hasn't, he
Collins.
hasn't signed his consent and the certificate and stuff. He still needs to sign that.
Ah, okay.
We were.
I unmuted it. I'll get that.
No, you haven't, sir.
Yeah, man, that's not. Can you hear me now?
Yes,
sir.
you need to sign another document, Mr. Collins. Just one
Okay,
second.
sorry, but yes, ma'am.
And Judge, can you put me in the breakout room with Collins?
Like, yeah, you know what I mean? But you know, then I'll have to do all the payments.
And I guess me as well.
All the UAs.
I'm sorry, what?
This time, like,
I'll go in the breakout room with Lupe.
if you can get that to your sentence, that'd be awesome.
Okay, if he's already signed the trial court certification, hasn't he already been sworn in or no?
No, he's not sworn in, Judge. He hasn't signed the certificate or even the
Okay,
consent.
can we please swear him in? Like, couldn't he have been
Thank you,
sworn in
Judge.
before? Thank you. All right, I'm going to send you to number 3. All right, who's on Soto?
That's me, Your Honor. Matthew Allen.
Marcus.
All right, thank you. All right, the court is calling 2021 CR 0236, State of Texas versus William Alexander Soto. Can I have parties announced for the record, please, for the state?
Marcus Sanders.
For the defense?
Matthew Allen.
And are you Mr. Soto? Could you unmute for me, please?
Well,
Are you Mr. Soto?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objection from the defense?
No, Your Honor.
And are you Mr. William Soto?
Yes, ma'am. Yes,
All
ma'am.
right, Mr. Soto, I see that you're able to mute and unmute yourself. If you
Yes.
could please mute yourself, and I'll ask you to unmute when it's time for you to say something. All right, we're proceeding by video because of the pandemic. Any objections from the state?
None.
Any objections from the defense?
No, Your Honor.
Mr. Soto, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Soto, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving the enhancement paragraphs.
Any objections?
No objection.
Mr. Soto, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Soto, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
The court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement. Did you review that document with your attorney? Did you understand it? Did you, sorry, just 1 second, I'm reading the chat box. All right. Did you review that document with your attorney and did you understand it?
Yes, ma'am. Yes, Your Honor.
All right, off the record for a moment. Kelly McGinnis, if you could go to breakout room number 1, and Joe Ray, if you could go to 1, please. We're back on the record. According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state will take in consideration grand jury number 751981. There's to be no contact with Maria Rios or Andres Alcaraz, ALCARAZ. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is that the plea bargain agreement.
Yes, Your Honor.
State is that the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places? Mr. Soto.
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, Your Honor.
Then to the offense is charged in the indictment. How do you plead, Mr. Soto? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, the state offers State's Exhibit 1 and its attachments.
Any objections?
No objections.
Mr. Soto, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Off the record. Ms. Ferguson, could you please go to breakout room number 2? Thank you. We're back on the record. The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Judge, just other than Mr. Soto, this is our first setting. We reviewed discovery ahead of time. Mr. Soto is clear that he wanted to take responsibility and not waste the court's time or have the victim come in or be contacted multiple times over and over again. And so we would just ask the court follow the plea bargain agreement.
All right, it appears from reading the facts of this case that this should be an affirmative, this should be a family violence case.
Yes, Your Honor.
All right, Mr. Soto, do you understand with an affirmative finding of family violence that you're not allowed to own or possess any weapons or ammunition?
Yes,
And do you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
yes, Your Honor.
All right, and knowing those things, do you still wish to continue with this plea bargain agreement?
Yes, Your Honor.
And are you asking the court to follow the plea bargain agreement that's been reached?
Yes, Your Honor.
All right. Then after reviewing state's exhibits 1 and attachments, of course, as previously stated, the court will find the defendant guilty. The court will sentence you to 3 years in the prison. There's an affirmative finding of deadly weapon, affirmative finding of family violence, taking consideration grand jury number 751981. There's to be no contact with Maria Rios or Andres Alcaraz. How do you pronounce that last name? Someone help me. Alcaraz?
Alcaraz, yes.
Alcaraz, okay.
Yes, ma'am.
Plus credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction and because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, yes, Your Honor.
All right, we can go off the record. Mr. Soto, in life as you go forward, when somebody doesn't want to be with you, they don't want to be with you. And obviously you have some anger issues. You need to take care of that because otherwise one of two things is going to happen. Either you're going to find yourself spending the rest of your life in prison, or either someone's going to end up injuring you. You understand?
Yes, ma'am. Yes, Your Honor.
And the neck tattoo, was that painful?
It was to be honest, it was one of my ex-girlfriend. It was a cover-up, but it's a guardian angel. But yes, it was painful. And how can I say this? I didn't mean to bring this up, but I understand it was a regular assault charge, but I don't understand how it became aggravated assault when I never, you know what I mean? But the police report, I know sometimes they
I tell you what, Mr. Soto, from reading the police report, it is an aggravated assault.
Okay. And I didn't mean to, I didn't want to, bring it up and make, I didn't
No, Mr. Soto.
interrupt you or nothing.
No, Mr. Soto, communication is key. If there's something you don't understand, that's why you ask people, right?
Yes, ma'am. Yes,
there's
correct.
no harm in asking people questions. That's why I always ask people about tattoos.
Yes, and I just want to tell you, thank you, and I do want to take responsibility for my actions, and I do believe just because I'm incarcerated and stuff like that, people do change, and I do have faith in myself, and I do have faith in a lot of people that are locked up right now, and I believe that they will succeed in life. You know what I'm saying? I'm not perfect myself, and I did have my priorities right out there and stuff like that, but I give thanks to the Lord because I know He's given me a second chance, even though I had to go back for a little bit or whatever the situation is. I do give thanks to the Lord for this day,
Well, I hope everything works out as well. And I hope that everyone always learns something. Life is a journey, right? And we're supposed to learn as we take our journey and hopefully not repeat same mistakes.
Yes, ma'am.
And I know you've learned, don't put the names of people on your body.
No.
Brenda, you know what I always say? The only people's one, why are you putting names on people's body as though you can't remember them? But the only safe names are your mom and your children. Those are
Yes.
safe names.
Yes.
Because your mom, she'll always love you, and you're supposed to always love your children.
Mm-hmm.
So now you have a cover up. Was your ex-girlfriend, was her name a long name?
No, it was a short name. It was a short name, yes.
Brenda, I remember Nick Cannon got Mariah Carey's name on his entire back. Now he has an entire back cover up. All right, Mr. Soto, good luck to you. Have a great rest of your day. Norman, can you let them know 14F can go back?
Okay, thank you. God bless you.
Oh, thank you. God bless you too. Thank you, Mr. Allen.
Have a good day.
Thank you, you too. Who's the attorney on Mr. Collins?
Oh, what, Judge? We're ready.
Hunter Morris, Judge.
Oh, and Mr. Morris, sorry.
Okay.
You mean the other attorney? Okay.
No problem.
And Judge, on this, I just realized, I think the paperwork is silent as to the state's recommendation.
Okay.
I do need to correct that. I believe the recommendation is deferred.
All right, let me check. All right, I will check that you are recommending deferred adjudication.
Thank you, Judge.
Thank you. And Ted Wood, on your client, Mr. Stribling, was there something else that was needed?
Judge, Mr. Martin and I discussed a bond reduction on his cases. We came to a partial agreement. We just need to get in front of you whenever you have a few minutes, Judge.
Okay, all right. Just if you all will send an agreed, is it completely agreed or is there some argument?
No, Judge, it's not. It's not completely agreed.
All right, just give me a moment then. Court is calling 2021 CR 8348W State of Texas versus Christopher Lee Collins. Can I have parties announced for the record for the state? For the defense?
Oh, what, on behalf of Mr. Collins, he's present. We are ready.
Are you Mr. Collins?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
None, Judge.
Any objection from the defense?
No, Your Honor.
Mr. Collins, I'm showing you what's entitled Defendant's Consent to Plea by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Collins, I'm going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
I know the charges, ma'am. I know to the fully.
No, my question is, did you review that document with your attorney? Did you understand it?
Yes,
And
ma'am, I
did-
sure do.
Okay, and did you sign it?
Yes.
Did you understand that you have a right to have a grand jury hear the evidence in this case, make a decision on whether to indict and hold you over for trial? And also your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I sure do.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm showing you what's entitled Information. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Collins, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is unlawful possession of a firearm by a felon? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Collins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I sure have. I call a gun a little bit later on in my life. Although I may be
Just 1 minute, Mr. Collins, just 1 second.
Piss her off.
I think she got a.
Sorry, Your Honor.
I'm sorry.
It's all right. It's all right. It's
Just
all right.
1 moment.
I made you mad. My bad.
No, you didn't make me mad. But
Anyways,
just give me a moment,
I'll
Mr.
let-
Collins. Mr.
all right.
Collins? All right, so Mr. Collins, I'm gonna ask you certain questions. And you haven't made me angry, but when I ask you a question, what I need you to do is listen to my question and answer my question, okay?
Okay.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a US citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you
Yes, ma'am, I
understand it?
sure did.
According to the plea bargain agreement, state is proceeding on count 1. There's a $1,000 fine to be probated. State recommends deferred adjudication, taking into consideration 632205. There's to be no contact with Ernesto's auto sales, no contact with Rogelio Sosa from cause number 632205. There's restitution, if any, to Ernesto's auto sales. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am, I sure did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for 3 years. There'll be a TAP evaluation, 100 hours community service restitution, and a mixed mild evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in the information. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
State offers state sworn in attachments, Judge.
Any objections?
We've had an opportunity to view it and have no objections.
Mr. Collins, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Your Honor, can I?
Just a moment.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, we may, Your Honor. We'd waive PSI.
All right, anything you wish to say on behalf of your client?
Judge, the main thing is when I first met him, he told me he wanted Stacy Krause to be present. Whatever I would do, I clear it with Stacy Krause. So I talked with Ms. Krause. She remembers him well. She said she could not be here today, but she wished Mr. Collins well. I think he just told you he's satisfied with what I've done for him today. He is not, he is homeless, but he told me he's got plans to go to housing for a Section 8 apartment, and that's his goal when he gets out. So he will meet, or assuming he gets out tonight, he'll meet with probation tomorrow and start the McMyoff evaluation.
Okay, Mr. Collins, how did you become homeless?
Want to be honest with you, Honor? I lived at 102 Chicken Avenue. The landlord was being a scumlord. He was taking my money and not making unit repairs. So I refused to pay the rent. I tried to fix my electricity, would not do so, and he threw me out. I'm gonna be honest with you. That's the honest to God's truth.
All right, so have you ever been homeless before?
Yes, I have about like 10, 15 years ago.
Okay, why were you homeless then?
Because the boarding home I was in was closed down due to money racketeering with Medicaids. Like the lady, okay, she owned a boarding home and she owned a daycare, right? Her name was Sherry Lynn Moses. That's who I used to live with. Everybody's seen the news report on Channel 12, okay. But it was supposed to have gone to her daycare, but she was reported us going to her daycare and still collected the money for it. See what I'm saying? It wasn't going there.
Okay. I'm amazed that people are allowed to have a boarding home and a daycare, but
well, yeah.
I mean, no. We are where we are in this world.
Yeah, I know. I understand that.
Are you employed? When's the last time you had employment?
Well, actually, I get government benefits of SSI, Social Security income.
Okay, what are you receiving SSI for?
For schizophrenia and bipolar disorder, but I know the laws a little bit. I mean, just because I own a firearm, I wasn't going to go around shooting people. It's for self-defense and protection.
Well, Mr. Collins, you're not allowed to own a firearm because you're a convicted felon.
I don't see how. The last felony I had was brother with attempted theft, and that was a turnaround case. I spent 204 days in Berry County Jail.
Okay. Mr. Collins, you're not allowed to own a weapon, okay? Or have a weapon. You understand?
Yes, ma'am.
Where are you going to be living if you're released?
I guess back out on the streets. I ain't got no choice. I've been waiting for housing for 2 years, and housing's so screwed up. Excuse me for saying this. We're not trying to curse this high court matter. To apologize, but it's the truth.
Apology accepted.
But they have all these drug, all these drug dealers on housing that's clogging up the system. And people.
And you've been to Haven for Hope, correct? You've tried Haven for Hope, and
I have, but people steal from me over there. Homeless people steal from other homeless people who's trying to make it. That's uncalled for. I'm sorry. But anyways, that's besides the point, which is sad. It really is. I told that to other homeless people, and other homeless people say the same thing. It's stupid.
All right, have you ever used drugs, Mr. Collins?
I smoke a little bit of marijuana, but that's because it helps me with my mental conditions. I'm sorry. I smoke a little bit of weed. I do apologize. It helps me keep me somewhat insane. If I don't have it in my system, I'll go off the rails.
Okay,
Along with my Seroquel, my clozapam, and my Prozac.
okay.
I mean, weed makes me happy. Just leave me alone with my stuff and let me smoke a little bit of grass every so often. What's gonna hurt anybody?
Well, here's the thing, what I can tell you, Mr. Collins. I understand how you feel about weed and that it keeps you leveled out. But while you're on probation, you're not allowed to smoke marijuana.
And I can understand that.
Yeah. All right, this is what the court is going to do. Court is going to sentence you to 3 years deferred adjudication, $1,000 fine that will be probated, taking into consideration County Court Cause number 632205.
3 years, good Lord.
No contact with Ernesto's Auto Sales. No contact with Rogelio Sosa. Restitution, if any, to Ernesto's Auto Sales. 100 hours of community service restitution. Mr. Wood, I will waive 40 hours of that if he's obtained the COVID vaccine. I'm not.
Yes, I
forcing you
have,
to
Your
get
Honor.
All right, just provide proof and they'll deduct 40 hours from you.
I did that at Haven for Hope. Wait, I got a sign there myself.
Well, I appreciate
Your
you
Honor.
for getting that done, Mr. Collins.
Yes, ma'am. But why is it 3 years? I thought it was supposed to have been a year of probation.
It's you can get off early after 1 year. It's 3 years probation, but the judge can let you off early after you've completed 1 year if you've done everything asked. They've probated the fine, so it's not going to be money. It's going to be these community service hours. And she just told you she'll knock off 40
Okay,
hours.
okay, that's fine. That's fine. And do I have to do any drug tests?
Just one moment.
Yes, ma'am.
Proof of SSI within 15 days or proof of employment with 15 days. There should be no employment as a home health care provider or with minors. So if you provide proof of SSI, that will be sufficient, Mr. Collins. I'm going to do regular reporting, either in person or by Zoom, regular UAs. And I'm going to do Kevin, let's do a referral to felony drug court. And Mr. Collins, we'll see if felony drug court can take you right away. They will help you with your housing and whatever other situation you have, and that will be best for you. And we can do the mixed mouth evaluation. And Kevin, felony drug court while he's in custody, and they should see you either sometime this week or at the very latest Monday.
So Judge, is he going to stay in custody for these evaluations, or is he
Yes, he's staying in custody. Mr. Collins, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this
Can
is
I
a
say
plea,
something?
just 1 second, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And remember, Mr. Collins, you're not allowed to own any weapons because you're a felon.
Yes, ma'am.
Yes, Mr. Collins, what did you want to speak to me about?
Can I get the drug test waived?
No. I mean, but you know what? It does not hurt to ask. But I will tell you this, felony drug court, they're going to help you a lot with that. And they'll help you with your medications. They'll help you finding a place to stay that's safe. All right?
Oh, no. I don't do the
You're gonna do well, Mr. Collins. Trust me on that. I'm gonna send you to breakout room number 1. I know you're gonna be awesome on probation. Could probation go to breakout room number 1? And Mr. Collins, if you could go to 1, please.
Judge, before I go, can I get the cause number on this? I only have a night mag.
It's 2021 CR 8348W.
Thank you.
Happy Wednesday, everyone. Happy Wednesday.
Happy
All right.
Wednesday.
Yes. All right, Ted Wood on Stribling. Did you file a motion on that?
Judge, I filed a motion on the VPO. The attempted arson bond is in place, and there was an affidavit of surety to surrender on the drug case. Mr. Martin and I agreed on 10,000 for the drug case. My motion was filed strictly on the VPO for a reduction.
Okay. So if you can put in the email to me what your agreement is with Mr. Martin and include Mr. Martin in that agreement, because I only have one motion, and that's the 2021-6625, and I don't know what other motions, what other case numbers you're going under.
Okay, so you want to do this in email, not chat, correct?
Yes, email.
Okay. So please, Judge, give me those again so I can write them down. You need all the cause numbers.
Yes. And what your agreement is.
Okay, I'm gonna get on this right now, Judge.
All right, and I will take care of that.
Thanks, Judge. Appreciate it.
You're welcome. And do we need Mr. Stribling back or no?
Judge, are you at stephanie.boyd@bear.org?
Don't announce my email address on YouTube.
I'm sorry, Judge. I'm sorry.
Why does everyone do that, Brenna? I don't know.
No offense meant, Judge.
Okay. All right, Mr. Collins. I have placed it in the chat box. And everyone, I think we are done. Is that correct? Do we have anyone else on the docket?
Judge, I'm inclined to toss Mr. Collins some community service hours just for his honesty. He's very candid.
I think so. I love his honesty, right? All right. So everyone, we are done for today. And we will be back tomorrow at 9 a.m. So everyone have a great lunch. Mr. Wood, we're just going to stop live stream, but we'll stay on for me to do what I need to do on your case by email.
Thanks, Judge. Appreciate it.
All righty, everyone. Have a great lunch.